Welcome to Easy Learning. Consequently, it can safely be said that evidence of the above named witnesses, being against the above mentioned criteria, laid down in the above said section could not be approved under the law. Full stop. Certified that the statement of the accused has been recorded through advocate in his true words and it contains the true account of what has been stated by him and has been read over to him and he has put his thumb impression admitting it correct and the same has been dictated by me in open court. Full stop. Admittedly, advocate was not counsel for the above named petitioner, rather he was counsel for the complainant party. Full stop. It is contended that as personal appearance of the above named petitioner was dispensed with, hence his above said statement was recorded through his counsel. Full stop. If the situation was as stated above, even then the answer to the questions put under section 342 CRPC should have been made by the counsel of the said petitioner and not of the opposite party. Full stop. The above mentioned alleged contention could not be given any weight on the grounds that in the statement under section 342 CRPC, signatures and thumb impression of the above named petitioner are also available, meaning thereby that at that time, he was very much available before the learned trial court due to the above mentioned alarming defects. The trial could not be termed as per the procedure and law. Full stop. In such like situation, proper course is to direct for de novo trial. Full stop. Although, the learned appellate court under certain legal defects has set aside the conviction and sentence, awarded to the petitioners, by the learned trial court, but without disturbing the judgment of the said court, which is again patent illegality. Full stop.